binding general ruling on VAT, and it deals with the alternative documentary evidence that will be accepted by SARS to claim an input tax credit. And the background to this ruling is just again briefly that the South African Jazz Festival, a taxpayer, hosted certain international jazz festivals in Cape Town. And in the course of that enterprise, the taxpayer obtained sponsors who provided goods and services at the festival, and the taxpayer in turn supplied goods or services to these sponsors in the form of marketing and branding. It is therefore a barter transaction. I give you marketing and branding, you give me goods and services. And the services provided by the taxpayer to the sponsors were assessed by SARS to output VAT on the basis of the sponsorship agreement. So SARS said, you've got the sponsorship agreement, you've got a barter transaction, we're going to raise output tax on that, and the taxpayer conceded thereto. However, the taxpayer wanted to claim an input tax credit as well, but unfortunately, the taxpayer didn't have a valid tax invoice and sought to rely on the sponsorship agreements in total to claim the input tax credit. And of course, SARS did not allow this because the taxpayer didn't have valid tax invoices. But the taxpayer actually asked for valid tax invoices from the sponsors. And SARS is very much aware of that. And just remember something, if you make a supply of goods or services, you have to issue a tax invoice within 21 days, if I recall correctly, of making that supply. So the taxpayer was quite right in asking the sponsors to give an invoice as is required under the Act, but no invoice was forthcoming. And SARS knew this, and so the taxpayer nevertheless sought to claim an input tax credit. And to do that, the taxpayer relied on Section 27, amongst others, 20 sub 7 of the VAT Act. And what Section 20 sub 7 says, it says where the Commissioner is satisfied that there are or will be sufficient records available to establish the particulars of any supply or category of supplies, and that it would be impractical to require that a full tax invoice be issued in terms of this section, the Commissioner may, subject to such conditions as the Commissioner may deem necessary, direct that any one or more of the particulars specified in subsections 4 or 5 shall not be contained in the tax invoice. For example, the word tax invoice then doesn't have to be there. That a tax invoice is not required to be issued at all, or that the particulars specified in 4 and 5 be furnished in any other manner. So that's on what the taxpayer relied. To say, well, yes, fine, I don't have a valid tax invoice, but SARS, you have a discretion to accept other documents, to in fact accept that I can claim an input tax credit without having a full tax invoice. And the court said, yes, okay, I note your reliance on Section 20 sub 7, and yes, there are sufficient information available, as is required in Section 27. But the court held that the mere fact that the sponsors did not issue the tax invoice does not make it impractical for the full issue of a tax invoice, and therefore the taxpayer was not successful in its reliance on Section 20 sub 7. And so in turn, it returned to Section 16.2f. It returned to Section 16.2f of the VAT Act, which says that no claim may be made for input tax credits unless the vendor in any other case, so in any other case, except as provided for in paragraphs A to E, is in possession of documentary proof as is acceptable to the Commissioner, substantiating the vendor's entitlement to the deduction at the time a return in respect of the deduction is furnished. And SARS held that since the sponsorship of contracts or agreements was good enough for SARS to rely on in assessing the taxpayer to output VAT or output tax, they should be sufficient to allow the taxpayer to claim an input tax deduction under Section 16.2f. So in other words, the taxpayer, even though in this case he didn't have a tax invoice, was allowed to claim the input tax on the basis of Section 16.2f. And what happened, as one would expect, is there were consequential amendments to the VAT Act. And the first one is that SARS inserted Section 16.2g. So firstly, they amended Section 16.2f and then inserted 16.2g. If you look at the new version of Section 16.2f and you look at the judgment in the South African Jazz Festival case, you can almost see the amendment to Section 16.2f aligns perfectly to SARS's argument that they raised in the court case. So Section 16.2f is pretty much deleted to such an extent that you cannot use the precedent in the South African Jazz Festival case going forward because it's changed. But what they did do at the same time is they inserted section 16.2g, which does give some relief. But let's just look at how section 16.2g now reads. It says, in the case where the vendor, under such circumstances prescribed by the Commissioner, is unable to obtain any document required in paragraphs A to F, the vendor is in possession of documentary proof containing such information as is acceptable to the Commissioner, substantiating the vendor's entitlement to the deduction at the time the return in respect of the deduction is furnished. So two things. Section 16.2g says that, fine, even if you don't have, for example, a tax invoice, we can still allow you to claim an input tax credit. So it's almost like the follower on section 16.2f in the manner in which it read prior to the amendment. But it's very strict. It says, under such circumstances prescribed by the Commissioner, and further containing such information as is acceptable to the Commissioner. So there's two criteria in section 16.2g. The first is circumstances prescribed by the Commissioner, and the second is acceptable information. And what this draft binding general ruling does is it says, well, what is the acceptable information? And when you look at this extract from the ruling, it says, in respect of a taxable supply as contemplated in section 16.2a to b, your normal taxable supplies, the acceptable information that you should have is the identity of the supplier by means of a valid VAT registration number and registered or acceptable trading names, and in instances where the consideration in money exceeds 5,000 Rand for the particular supply, either the recipient's valid VAT registration number or the recipient's registered trading name, the date on which the supply was made, a proper description of the goods, and we can go on in going through this. But the fact of the matter is, when you look at this, you could just as well have gotten a tax invoice, because when you look at section 25 of the VAT Act and you look at the documents or the acceptable information, then it's almost to a T. It's just it doesn't have to be on a tax invoice. You can have it, for example, in an email format. And so it carries on, and it refers to, in respect of suppliers contemplated in section 16.2c. I'm on slide 88. And this is where we deal with certain second-hand goods. It says what you need then, if you don't have the prescribed documents for second-hand goods, the other acceptable information is the identity of the non-registered supplier. Must be confirmed as follows. If the non-registered supplier is a natural person, by means of a copy of the supplier's ID book or identity document. Or if the non-registered supplier is not a natural person, by means of a copy of the supplier's representative ID document or driver's license, as well as any document reflecting the legally allocated registration number for the supplier, a proper description of the goods supplied, any documents confirming that the supply is not a taxable supply, the consideration for the supply, and proof and date of payment. And you look at the requirements, the general normal requirements for claiming an input tax credit on second-hand goods, you will find that they are almost identical to what is regarded as acceptable information. So the relief it brings is not entirely clear. But nevertheless, that's what the draft binding general ruling says. And further, prescribed circumstances. So now we looked at what is the acceptable information. Because 16.2g says there's two criteria. It must be acceptable information, and it must be in the circumstances prescribed by SARS, or by the Commissioner rather. And the circumstances prescribed under yet a further draft binding general ruling on VAT is that you must have exhausted all means to try and obtain the correct supporting documents. In other words, you must have exhausted all means to try and get a proper tax invoice. Exactly what you're supposed to do is not clear from the ruling. It just says you must have exhausted all means. And further, you must retain proof of such attempts. And then they go yet further to say all taxes and returns must be up to date, and also only applicable to tax periods commencing on or after the 1st of April 2016. So very, very limited circumstances, but be aware when you look at section 16.2g, when you want to claim an input tax credit without having the proper supporting documents, you need to go to 16.2g, and you need to look at these binding general VAT rulings to make sure you fall in them.